Imagine building a life with a partner for 29 years. Now, you raise children together, you share a home, and you present yourselves to your friends and your community as a married couple.
In every conceivable way, yes.
Exactly. You build this entire ecosystem of shared existence. And then, well, the relationship ends.
And that is when the reality hits.
Right. Suddenly, you are facing absolute financial ruin. And this looming destitution, it is not because you did not contribute to the partnership, but simply because you are missing one single piece of paper.
A formal marriage certificate.
Yes, a formal marriage certificate. Welcome to this deep dive. Our mission today is to examine a landmark legal shift in South African family law, one that is dismantling the traditional barriers that have long penalized unmarried partners.
It is a critical shift, truly.
We are basing our analysis today on a pivotal case from the Western Cape Division of the High Court, which is known as P.A.L. versus R.J.T.
You know, it is a harsh reality that has trapped many individuals in this country. When we examine the situation through a professional legal framework, we see a profound disconnect between society and the state.
How so?
Well, society's definition of a relationship and what fundamentally constitutes a family unit has evolved considerably over the last few decades.
Right, our everyday reality has changed.
Exactly. However, the law has historically moved at a glacial pace. This delay in legal evolution has consistently left unmarried partners in a deeply vulnerable legal gray area.
Especially when the relationship falls apart.
Precisely. It becomes a crisis, particularly when those relationships dissolve and the actual financial realities of separation set in.
Before we delve into the specific legal mechanics of how the High Court approached this decision, I think we must understand the human reality that forced the court to re-examine the law.
The context is everything here.
It really is. In the matter of P.A.L. versus R.J.T., we are looking at an exceptionally long timeline. 29 years is an entire era of a person's life.
It is a lifetime of shared investment.
Yes. During that time, the couple in question was entirely integrated as a family unit. Yet, upon separation, the partner who was financially dependent faced immense, immediate uncertainty.
They were left completely exposed.
To put this into perspective for you, think of building a massive, complex commercial enterprise over 30 years, but doing it entirely on a handshake.
That is a very apt comparison.
You invest your time, your energy, and your resources to build the infrastructure. And when the partnership dissolves, the lack of a formal, written contract suddenly threatens to erase decades of your shared investment. You are left with nothing.
That business analogy captures the vulnerability perfectly. In family law jurisprudence, we refer to this as the legal gray area for unmarried permanent life partners.
And he's been that way for a long time, right?
For generations. Despite a partner's undeniable and extensive contributions to a shared household, the strict absence of a marriage certificate served as an insurmountable barrier.
Even if they raise the children or manage the home.
Yes, whether those contributions were strictly financial or in the form of managing the domestic sphere so the other partner could build wealth. The law historically viewed formal marriage as the sole recognized gateway to claiming maintenance rights.
So no certificate, no support.
Exactly. The legal philosophy was that the state needed a clear, registered contract to enforce obligations. If you did not cross that specific threshold, the court systems generally would not enforce financial support upon separation.
So following the dissolution of this 29-year partnership, the dependent partner is staring down financial ruin. They have to take immediate legal action.
Because they simply cannot wait.
Right. They cannot wait for a final divorce settlement because technically there is no divorce to file. This urgency led to a crucial standoff in the Western Cape Division of the High Court.
The application for interim maintenance.
Yes. The applicant sought interim maintenance, which is temporary financial support, just to survive the ongoing legal uncertainty while a main case could be finalized.
And the respondent fought this aggressively.
Heavily contested it.
Yeah.
But they did not just argue about the facts of their relationship. They focused their defense heavily on jurisdictional issues, arguing the court did not even have the authority to grant the request.
Which is a very specific legal tactic.
Okay, let us unpack this strategy. If you are the wealthy partner with high-powered representation, why attack the jurisdiction at all? Why not just argue that the relationship did not involve any explicit financial agreements?
What is fascinating here is the underlying legal warfare strategy. Challenging jurisdiction is not merely a technical argument.
It is intentional.
Highly intentional. It is a deliberate and effective tactic to starve the applicant out. By arguing that the High Court does not have the legal authority to even entertain the matter, the respondent attempts to close the courtroom doors before a single piece of evidence regarding the relationship is presented.
Wow, so they stop it before it even begins.
Precisely. We must contextualize the severe financial risk the applicant was facing. Everyday survival was on the line. We are talking about the immediate necessity of securing rands to pay for groceries, housing, medical aid, and basic daily needs.
So you are saying the wealthy partner is using the structure of the legal process itself as a weapon.
They absolutely are.
They are banking on the fact that the dependent partner will simply run out of rands before a judge ever looks at the actual facts of their shared life.
That is the practical reality of litigation. The applicant required this financial support in South African rands simply to sustain themselves while waiting for the main action to be resolved.
Because these trials can take a long time.
Oh, running a complex trial regarding the establishment of a permanent life partnership can take years. If you tie the matter up in jurisdictional red tape at the very beginning, the dependent partner exhausts their resources.
They cannot afford their legal representation anymore.
Exactly, nor can they afford basic living expenses. Ultimately, they are forced to abandon the claim entirely.
So the judge looks at this wealthier partner trying to shut the door before the trial even begins, and the court essentially says, well, not so fast. We have to look at the immediate reality here.
But they must do so within a strict legal framework.
Right. The judge cannot just hand over the money based on sympathy. Because the stakes were incredibly high, the court had to apply a stringent legal standard to justify bypassing the traditional requirements of a formal marriage.
They utilized a specific four-part test for interim relief.
Let us look at how this played out in the courtroom. The very first hurdle the applicant had to clear was establishing a prima facie right. The court recognized that the applicant had a right to support based on long-term financial interdependence.
Correct.
But I must push back on this point entirely. How can a high court determine a legal right to financial support without the black and white proof of a marriage certificate? Does this not set a dangerous precedent?
It is a valid question.
I mean, could any long-term roommate suddenly claim financial dependence just because they shared an apartment for a few years?
The court draws a very sharp and deliberate line there, which highlights the rigorous nature of this four-part test. A roommate situation would fail this examination at the very first hurdle.
Because it is not just about time spent together.
Exactly. The court does not merely look at the duration of shared living space. They examine demonstrated systemic financial interdependence.
What does that look like in practice?
Well, to establish a prima facie right, which essentially means a right established at first glance pending the final trial, the court scrutinizes how the parties conducted their financial affairs over nearly 3 decades.
So they look at the actual evidence of their life.
Yes. Did they hold joint bank accounts? Did they purchase property together? Did they draft wills naming each other as primary beneficiaries?
I see.
And most importantly, did one party systematically sacrifice their own independent career progression to manage the household and raise the children, thereby enabling the other party to accumulate wealth?
So the prima facie right in this context is established by the factual lived reality of an intertwined life, rather than the existence of a state registry.
Indeed. The court acknowledged that a legally recognizable duty of support can, and does, arise from the explicit or implicit agreements made during a permanent life partnership.
So 29 years is plenty of proof.
The evidence of 29 years of shared financial and domestic integration provided the court with enough substance to say that, on the face of it, a duty of support exists, regardless of the lack of a certificate.
That distinction makes the threshold much clearer. It is about systemic integration, not just cohabitation. Now, establishing that right brings us to the second part of the test. The applicant then had to prove they were facing irreparable harm.
Yes, the threat of absolute ruin.
In the context of P.A.L. versus R.J.T., the court identified this as the obvious risk of sudden financial instability. This ties directly back to what you mentioned earlier regarding the strategy of starving the applicant out.
It is the direct legal countermeasure to that strategy. Irreparable harm means that if the court fails to intervene immediately, the damage suffered by the applicant cannot be rectified later.
Even if they win the main trial eventually.
Precisely. Even if they're ultimately victorious years down the line. We must look at the human cost. If an individual loses their housing, defaults on medical aid, or cannot purchase food today, a financial payout 2 years from now does not undo that period of intense suffering.
The damage is already done.
Exactly. The court recognized the severe asymmetry in financial power between the two parties and the devastating, irreversible consequences of judicial inaction.
Wait, if I am facing absolute destitution and I have proven that I will suffer irreparable harm without immediate financial intervention, then the next requirement of the test, the balance of convenience, seems entirely redundant to me.
It often appears that way to the applicant.
I mean, obviously, it is far more convenient for me to not starve on the street. Why does the legal system treat the balance of convenience as separate, distinct hurdle that must be cleared?
While it may seem redundant from the perspective of the applicant, the court is obligated to remain impartial and weigh the potential prejudice to both parties.
So they have to look at the wealthy partner side, too.
Yes. The balance of convenience is the mechanism the court uses to evaluate competing interests before the final facts are proven at trial. If the court grants the interim maintenance, it must ask, what is the prejudice suffered by the respondent?
Which is usually just money, right?
Usually for a wealthy respondent, the prejudice is a temporary reduction in available liquid capital. It is a measurable loss of rands in the short term. However, the court must then ask, if we deny the maintenance, what is the prejudice to the applicant?
And as we establish, it is absolute financial devastation.
Precisely.
I see. So it's a mechanism of measuring proportional impact.
Exactly right. The balance of convenience prioritizes practical fairness and equity over rigid legal tradition. The court determined, in weighing these two outcomes, that it is far more equitable to compel the wealthier partner to provide temporary financial support
Than to just let the other person lose everything.
yes, than to allow the dependent partner to fall into ruin while the slow machinery of the legal process unfolds. The temporary financial inconvenience to the respondent is vastly outweighed by the existential threat to the applicant.
That framing makes the necessity of that third step much more apparent. It is about ensuring the court's intervention is proportionate. This brings us to the final requirement of the four-part test, which is proving that there is no alternative remedy.
This is a crucial administrative check.
The court acknowledged that the applicant had absolutely no other recourse until the main legal action concluded. But why is this the case? Surely there are other social or legal mechanisms available to someone in financial distress.
In the context of enforcing a duty of support between two individuals, the legal avenues are strictly defined.
You cannot just go to any court.
Exactly. The applicant could not simply approach a different court or utilize a different area of commercial law to demand this specific type of temporary relief. They could not apply for state grants that would adequately replace the standard of living established over 29 years of a joint household.
That makes sense.
The interim maintenance application under the jurisdiction of the High Court was the sole legal avenue available to compel the former partner to fulfill that implicit duty of support and prevent destitution.
So, by systematically satisfying all four parts of this rigorous test, proving the prima facie right through systemic interdependence, demonstrating the imminent threat of irreparable harm, showing that the balance of convenience heavily favored intervention, and proving the strict lack of any alternative remedy, the applicant built an undeniable case.
A very strong legal foundation.
They provided the court with the necessary grounds to grant the relief, forcefully bypassing the historical requirement of a marriage certificate.
They did, and in doing so, they achieved a significant legal victory. But the successful application of this test in this specific matter achieves substantially more than just solving one couple's immediate financial crisis in the Western Cape.
It sets a precedent.
It establishes a vital precedent. It creates a definitive ripple effect across the entire legal landscape of South Africa. The judgment in P.A.L. versus R.J.T. is a profound evolution.
It changes everything.
It actively challenges and in many practical ways dismantles the traditional legal barriers imposed solely by the lack of a formal marriage document.
So what does this all mean for the future of family law in this country? We are moving away from a system that demanded strict documentary compliance. Where does this jurisprudence lead us?
If we connect this specific High Court decision to the broader legal picture, we see a crucial alignment happening. This judgment fundamentally aligns our family law with broader constitutional values.
The Constitution itself.
Yes. The South African Constitution is deeply rooted in the foundational principles of equality and human dignity. For decades, legal scholars have argued that the differential, exclusionary treatment between married couples and unmarried permanent life partners infringed upon those core constitutional values.
Because it treated them as lesser.
Precisely. By denying protection to interdependent partners simply because they lacked a certificate, the law was failing to protect their dignity.
It essentially treated their decades of commitment as legally invisible, which is an inherent affront to their dignity.
That is the crux of the constitutional argument. This ruling sends a clear, unequivocal message from the judiciary. Actual lived dependency and permanent life relationships deserve legal acknowledgement and robust protection, regardless of marital status.
It is about reality over bureaucracy.
Exactly. The court is prioritizing the substantive reality of the human relationship over the formalistic administrative requirement of a state registry. It is an acknowledgement that the law must serve the people as they actually live.
Rather than forcing people to conform to outdated legal structures just to secure basic financial protection.
Exactly that.
It is a profound shift toward equity. To concisely recap our core takeaway from today's deep dive analysis, the Western Cape High Court ruling in P.A.L. versus R.J.T. serves as undeniable proof that the South African legal system is finally looking past the paper.
Moving into the modern era.
Yes, it is evolving to recognize the reality of modern financially interdependent relationships. This ensures that vulnerable partners are no longer left unprotected and facing destitution simply because their decades-long commitment was not formally registered with the state. The lived reality now carries heavy legal weight.
Before we conclude our analysis today, I must provide a formal and necessary disclaimer regarding the content of our discussion.
Of course.
Kindly note that the contents of this deep dive are intended for informational and educational purposes only. The discussion and analysis provided do not, under any circumstances, constitute formal legal advice.
Everyone's situation is unique.
Very much so. The application of South African family law is highly complex and is entirely dependent on the specific, unique facts and circumstances of individual cases. If you find yourself in a similar legal gray area, you are strongly urged to consult a qualified legal practitioner or attorney to seek guidance tailored to your specific legal circumstances.
We began this discussion by asking you to imagine building a life with a partner for 29 years, investing your time, your energy, and your heart into a shared existence, only to face absolute financial ruin over a missing document.
A truly daunting scenario.
The High Court, in this matter, recognized the inherent devastating injustice of that scenario and took decisive action to rectify it. But as we close, this legal evolution leaves us with a final, broader question for you to ponder.
And it is a significant one.
As society's definition of family, partnership, and commitment continues to evolve at a rapid pace, moving much faster than our formal legislative texts, how many other traditional legal boundaries will soon be dismantled by the everyday realities of modern relationships?